hello there. We're back. You're back. Good to have you along for the ride. Ask a Lawyer here on CP24. John Scholes, right in your camera, right in your TV, and momentarily joined by employment lawyer, of course, Lior Samfiru from EmploymentLawyer.ca. Always off the top, I'd like to give you that contact information to reach out to Lior anytime. On your own time, might be necessary, might just be a simple chat. Same number regardless. Here it is, 1-855-821-5900. Ask at EmploymentLawyer.ca. We'll give you some more contact information throughout the show as well. Busy show, like it always is for this half hour as you tune in every week, hopefully, and join us. Major topic today will be, in just a bit on the next segment, will be important employment law terms and why they're so important. They're very common ones. We'll get to 3 of those, but you're going to remember them when we're all done. That is coming up in just a bit. Some phone calls from one of our radio shows. I want to tell you about that ahead of time here as well. Sundays, 1 p.m. here in the GTA. You will catch us on News Talk 1010. Join us, call in for that hour-long show, and you might, well, your voice might be on this show at a later date. So that all said, we got lots to get through. Lior, we always start off with the week that was, or case of the day, pal. There he is. What's going on this week, my friend?
Hey, John. Great to be here. Great to be talking employment law. You know, I come here for a half hour. I do this show on this station, but the rest of my time, I'm not stopping talking about employment law. I'm talking with individuals every day that call me, that email me, that want to know their rights, that have workplace problems. That maybe are dealing with a difficult situation. Maybe they're being mistreated by their boss. Maybe they're facing certain ultimatums, or they lost their jobs, temporary layoffs. I talk to them, I help them, and I explain what the law is. That's what we do on this show. We tell you what you need to know. We answer the questions, and we make it easy so you don't have to worry about, well, do I go to Google to find an answer? Do I ask my cousin Bob? You get the right answers right here, right now. And again, 30 minutes, but after that, you can call me in the office. You can email myself and my team. We can help you and get really involved in making sure that your employment law issue gets resolved. So don't hesitate to make that call. So let's start with my case of the day, a situation that I dealt with very, very recently. Now, I spoke with a gentleman that was hired by one of the big banks as an IT consultant of some kind. I say some kind because I don't really understand that type of work. I'm just a lawyer. But he was provided or hired to provide IT services. Now, he was hired, quote unquote, as an independent contractor. And I'll say why in quotations in a second. So he started there, but when he worked there, he was given a company laptop. He was given a bank email address. And he did this job. And after about 4 or 5 months or so, he was let go. Bank said, you know what, we actually probably don't need you, so we're going to let you go. Even though you're an independent contractor, we don't owe you anything. Bank said, well, we'll pay you a week's pay because we're very nice. He contacted me and he wanted to understand his rights. Really, he wanted to understand, does he get anything in this situation having lost his job as an independent contractor? Well, the first thing I noticed and the first thing I told him is he was not an independent contractor. He was really an employee. He worked for the bank for several months just for them with a company email and a company laptop. He couldn't be more of an employee if he tried. Doesn't matter that the bank called him an independent contractor. He was an employee. And why is that important? It's important because due to the fact that he's an employee, he's owed severance. And yes, even after 4 months of working, he was probably owed about 3 to 4 months of severance. Not a week's pay, which is what they told him they'll pay him, 3 to 4 months. So there's some important lessons here. Number one, it is extremely common for individuals to be misclassified as contractors when they truly are employees. It's a pretty simple test, actually. If you look like an employee and act like an employee, hey, guess what? You're an employee. And the second thing, of course, just because you work for a company for a short period of time doesn't mean you don't get a lot of severance. You do. Short service employees have substantial severance entitlements. And by the way, just because you work for a big company, in this case a bank, doesn't mean that they're doing things correctly. Oftentimes with big company, they still make the same mistakes. They still break the law, maybe unintentionally. So big company, small company. If you're worried about your entitlements, if you lost your job, you have to give me a call.
Yeah, Lior, seems like one of those situations you've talked about where a short service employee, the severance can actually eclipse the amount of time they work there, which is interesting.
It's quite often when the amount of severance or the length of severance is greater than the length of employment. Remember, the factors are age, position, and length of employment. So if you work for a few months, but you're older and you have a more senior position, you're absolutely able to do that. There could be people that are owed 12 months severance, even though they only worked for 6 months. Happens all the time. So that's why we're here to talk to you about your entitlements. Don't make any assumptions.
I did mention off the top our radio show, News Talk 1010, locally here in the GTA, Sundays, 1 p.m. Lior and I join in to that show, join the conversation, make the phone call. Want to get to our first phone call from the radio show right now. Lior, so let's listen up and then dissect it after it's all done, right?
Last Wednesday, I received a written notice that my employment will be terminated, and I was escorted from the office. There is no specific cause of the dismissal, rather than the business is very slow. So my question is basically because I worked for the company from 1998 to 2006 and then resigned, and I was rehired from 2012 to now. Am I entitled to severance pay? I had a manager position and around 140K.
Very good question, and certainly something that I see come up very often. So the first thing I'll say right off the bat is, of course, even though she may have done nothing wrong, severance has to be paid. The real question here is how much service does she have? What is the length of her employment? Now, in many cases, when you work for a company, you leave and then you come back later. In many of those cases, we can combine the periods of employment so that you have more service. It really comes down to whether or not when you came back, were you treated as a new employee? Did they put you on probation, in which case you're a new employee, or did they essentially acknowledge the fact that you had past history with the company? In many cases, even though there's a gap in employment, we can disregard that gap and combine the years of service. So if we can do that for her, that means more severance. So I'm going to go now and use the severance calculator tool. You can find that at EmploymentLawyer.ca. And let's plug in that information and see what you would get in that situation. So we know she's 58 years old in a middle manager position, been there for 20 years if we combine both times, both lengths of employment. Severance for her, you see right at the bottom, will be 18 to 24 months pay, 18 to 24 months. So if you have a gap in employment, that gap may not matter. You may still be entitled to severance based on your total years. By the way, EmploymentLawyer.ca to use the severance calculator. It's free, it's anonymous, so check it out.
All right, Lior, good start. Got to slide into a quick break, which we'll take care of now. On the other side, the main topic, common employment law terms and why they are so important. That is on the other side as we continue. Ask a Lawyer here on CP24. Don't go anywhere.
Lost your job? Disability denied? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Mondays and Wednesdays at 9 p.m. on CP24.
Okay, welcome back to Ask a Lawyer, CP24, John Scholes, and of course, Lior Samfiru, always reachable by phone, don't you know? 1-855-821-5900. There's the email, ask@employmentlawyer.ca, and you can also scan that QR code on the right side of your screen anytime when we pop it up on the screen, so take advantage of that. Main topic, time, and it's going to be common employment law terms, why they are so important. We whittled this down to 3. We could have done 300, Lior, but we're going to do 3 for the show. Today, the first one, always confusion with this, wrongful dismissal. Break that down for me.
Yeah, wrongful dismissal. Now, the name suggests that your dismissal is wrong, and a lot of people believe that to mean that I was let go for the wrong reason or a bad reason or no reason, that it had something to do with why I was let go. Unfortunately, that's not the case. A wrongful dismissal has nothing to do with why someone was let go. A wrongful dismissal is simply a situation when you're let go and you have not been paid your proper severance. A wrongful dismissal is all about severance. So as a non-unionized employee, you've been wrongfully dismissed. If you lost your job and the severance that the company's offered you is not appropriate, keep in mind, in over 90% of cases, when someone has been let go, they have been wrongfully dismissed because the severance that they've been offered is not adequate. So you may have been let go and you think everything is fine, except you probably have been wrongfully dismissed. 90% of the time, that's the case. Remember, your employer is allowed to let you go at any time and pretty much for any reason, but they have to pay severance. So if you've been let go, you want to know, you need to know, you must know if you've been wrongfully dismissed. you can use the severance calculator, or you find that at pocketemploymentlawyer.ca. You can call me, because chances are, wrongful dismissal is something that just happened to you.
Okay, that's the first one, wrongful dismissal. The companion term to that, also confusing for people, constructive dismissal. Difference?
That's right. So a regular dismissal, you've been called into the office, you've been let go, company says you don't work here anymore. A constructive dismissal is different. A constructive dismissal happens when you consider your employment as being terminated. You've decided that your employment has been terminated because your employer made significant changes to the terms of your employment, like your pay, your hours, your responsibilities. An employer does not have a right to make such significant changes. And if they do, that may give you the right to say, wait a second, employer, I am deciding to consider this my termination. I'm considering this a constructive dismissal, and now you have to pay me my full severance. By the way, that could be as much as 24 months' pay. So constructive dismissal, different than a regular dismissal in that the company is not letting the employee go. The company is not saying you're gone. In fact, the company expects the employee to continue working. But with a constructive dismissal, the employee is saying, I've decided based on what the employer has done, that's a termination. Now I'm owed my severance.
Okay, let's get to our third term, common terms that we use on the show as well, by the way. Just cause of dismissal, just cause for dismissal. What does that mean?
So just cause happens when an employee can be let go with no severance at all. Now that is the capital punishment of the employment relationship, and that can only happen. You can only be let go for cause without severance if you've done something so bad that it's impossible to continue employing you. Again, it's the capital punishment. So just like we don't give capital punishment for someone that just did something wrong, it has to be pretty bad. The same thing with a termination for cause. Now here's the thing, John. In the majority of cases, when an employer alleges cause, says that they have cause, they don't. The employee didn't do something to warrant that punishment, which means that employee is still owed severance. So even if you did something wrong, it does not mean that the company can let you go for cause. Very difficult to terminate for cause. So absolutely you must call if the company is saying that that's what they're doing.
Great stuff, Lior. Always love covering that main topic. I want to get to another phone call from our radio show. Reminder once again, locally here in the GTA, if you catch radio, it's News Talk 1010. Lior and I, Sundays at 1 p.m. Phone call number 2. Let's have a listen.
Same full-time job for 11 years. I want to reduce my hours with my doctor's support. Due to a medical condition, I would like to request a 3-day work week rather than a 5-day work week due to the medical condition. Can an employer say, we cannot accommodate that arrangement, we will terminate you?
Wow.
That would be illegal, John. They cannot do that. An employer has a very strict duty to accommodate when it comes to your medical restrictions. Now, it all starts with that doctor's note. If your doctor says that for medical reasons, you need to reduce your days of work from 5 to 3, your employer must accommodate. It's going to be almost impossible for your employer to say, oh, we just cannot do 3 days, it has to be 5. Your employer has to accommodate even if it's difficult, even if it's costly, even if it's not something they want to do, they have to do it. And if they don't, that's a human rights violation. It's illegal. And you can certainly not be terminated because you have a medical condition that needs accommodation. So get that doctor's note. If your employer won't accommodate, if they refuse, if they don't believe your doctor, if they demand you get a second opinion, if they do any of that, you got to give me a call. That's not legal, and the law has no patience for any of that.
All right, Lior, good stuff. Thank you, pal. We're going to give you a bit of a reprieve. We're going to jump tracks here momentarily after the other side of the break. Our good pal James Fireman is here on the disability side of what the firm does. We'll talk to James, see what he can teach us in just a few minutes as we continue Ask a Lawyer on CP24. Don't go anywhere.
Lost your job? Disability denied? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Mondays and Wednesdays at 9 p.m. on CP24.
Welcome back to Ask a Lawyer. As promised, our good pal James Fireman is here representing the disability side of the firm, and always reach out for that free consultation. James, good to have you on the show again this week. You always got something interesting to say. First of all, why are you, well, I know why you're here, but why are you here? What do you do?
Well, a lot like Lior does for anybody who's got an employment issue. Lior and his team are there to help. We're there, the disability team is there to help for anybody who has an issue with their disability insurance. And I know it's not something that most people spend a lot of time thinking about. Most people don't spend any time thinking about their disability insurance coverage until they have a disability that prevents them from being able to work. And when people get into that position and apply for disability benefits, usually what they find out is the process is complicated. It is frustrating and confusing, but the good news is that's why we are here. We offer 100% free consultations for anybody who is involved in the disability insurance process, whether you've just applied or whether you're dealing with your insurance company and they're asking you for various documents, or if you've gone through the process and you were approved and your benefits were terminated, or if you were just denied outright. That's what we're here to do. If you have any questions about the disability insurance process, that's what we do.
And I will tell you right now how to reach out to James and his team anytime. Same number, 1-855-821-5900. Ask at disabilityrights.ca. First of two questions during your segment now, James, an audio question. So listen up. It is coming at you. Here we go.
What should you do if the insurance company keeps denying your appeals for disability benefits?
This is a question that comes up all the time. And the reason it always comes up is because when your disability benefits are denied or if they're terminated, you're going to get a letter from your insurance company. And the letter is going to invite you to appeal their decision. The reason that that invitation is in there is not because the insurance company is required to do it. If you look in your policy, there will be nothing in there about the appeal process whatsoever. The reason the insurance company offers an appeal is because it allows them to maintain complete control over the process. So if you appeal, you are saying to the insurance company, I'm okay with you maintaining control over my disability rights. You do not need to do that. Your insurance company is in business to make a profit. That's what they're there to do. And if they have found a justification to terminate or deny your benefits, there is very little you can do to change their mind, unless you give us a call and you start litigation, which is much like what Samantha did. Now, Samantha didn't do this right away. Samantha was an executive who had a very significant back injury, and she wasn't able to sit for more than 20 minutes eventually, and she wasn't able to stand for more than 10. And her doctor said, there's nothing that you can do. Even a perfectly sedentary job where you're sitting at a desk all day, you can't even do that. She was denied when she applied for benefits, but she was invited to appeal, and so she did, and she was denied. But they offered her another appeal, and so she did again, and once again she was denied. And they offered her yet another appeal, and once again she appealed and was denied. In fact, she appealed 7 times. That's a record. I've never heard of anyone appealing that many times. Thankfully, those were all within the 2-year period after her initial denial, and she got our phone number and she gave us a call, and we were able to resolve her claim for more than 6 figures. It was a very significant result, and had she gone on and appealed one further time, she probably would have passed that 2-year mark and wouldn't have been able to do anything.
One quick question to wrap up your time here, James, is this: what should you do if your insurer insists you can work in a different job?
So this is a complicated question. It depends on where you are in the process. At the 2-year mark, there may be occasion for your insurance company to start exploring this once you've been getting benefits for 2 years. But it is very complicated. It can involve an employment law issue. And that's why if you are faced with that situation, if your insurer is telling you that you should be working another job, give us a call. You need to speak with a lawyer who is going to be able to discuss both your disability rights and your employment rights. And that's exactly what we do.
Good stuff, James. We'll take a short break now. We'll pop back in with Lior to finish off the rest of the show, so stay with us. Ask a Lawyer continues here on CP24.
Lost your job? Disability denied? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit CP24.com/askalawyer and watch Mondays and Wednesdays at 9 p.m. on CP24.
Welcome back to Ask a Lawyer on CP24. We will wrap up this week's show with a phone call reminder. Make that phone call. You might get on air as well. How do you do that? I'll give you the phone numbers first. 1-855-821-5900. Email ask@employmentlawyer.ca. And then Sundays, 1 p.m., join us for the radio show, News Talk 1010. That's locally here in the GTA. All right, Lior, get those ears perked up. We're going to catch that one last phone call to wrap up the show. Here we go.
I had a stable job with highly specialized engineering knowledge. You know, I could tell from day one that my hiring boss didn't actually like me. Now, I've been there for a couple of years, and some of the stuff he said has been a little bit aggressive. I'm just wondering, with my age and the time, if he was to do something, would I have some sort of decent severance?
And the answer, John, for pretty much everyone is yes, you're entitled to some decent, probably even more than decent severance. So the best way to find out how much you're owed, which is what I'm going to do now, is to use the severance calculator. We're going to go use that at pocketemploymentlawyer.ca, and let's see what that gives us for this gentleman. So he's an engineer, been there for 3 years. He's 62 years of age. We can see that if he's let go, he's going to be owed right around 6 months severance. Now, that could be even more, given the fact that he's in a specialized position. So that's why you have to always remember, don't sign anything, not until you go to pocketemploymentlawyer.ca, use the severance calculator, or just call me.
Thank you, Lior. Wrapping it up nicely again this week, my friend. We'll leave it there for now. I'll give you some final contact information to reach Lior and the rest of the team at the firm. Phone number, 1-855-821-5900. Ask@employmentlawyer.ca is the companion email to go with that. And anytime you can go to pocketemploymentlawyer.ca. Use that severance calculator, free and anonymous. Any other time you want to reach out, cp24.com/askalawyer. And we'll catch you next week. Thank you for tuning in.